Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your Honor. Thank you for the opportunity. The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
It's what you do to me. Call me a lesson later, baby. I'm here for the kill. Talk dirty to me. I'll be assiduous, baby. You know the drill.
First of all, the first order is I want to thank the court for granting my permission to practice before the court.
Okay.
And I'll strive to comport myself to honor the opportunity I've been given.
Thank you.
You are muted.
Let's talk about professional credentials. You know what I mean by the term credentials?
Yes, I do.
Professional credentials are important in any profession, correct?
Correct.
And they're important in your forensic examiner profession as well.
Correct.
Your forensic scientists and examiners are no different than any other professional. That credentials are important. How they dealt with the chain of custody of the phone and how they examined it was completely wrong. And in the end, the fun part was, and it was almost like we were frenemies, right? Thank you. Oh, you're welcome, Mr. Alessi. You know, and it was kind of like a little bit of a competition of who was going to be nicer to the other one. And then in the end, when she admitted that the way they handled the phone, not putting it in a Faraday bag or Faraday box, and if you remember, and this was sort of the ultimate answer to your question, and most fun, when she admitted that, yeah, they should have done it much differently. And then she turned to Attorney Brennan after she gave the answer and conceded it. And it's how I ended my cross. And she turned to him and said, sorry. She mouthed to him, sorry, like, sorry, I had to agree with Attorney Alessi on that. That she was the one I had the most fun with. If I could,
Please.
and I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swiped. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022.
isn't there activity on that phone, health data activity, up to around noon of January 29?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device, so if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that, Tom? Nick? Thank you, Your Honor. I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So, the iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's either to be put in airplane mode, Faraday bag, or Faraday box. Is that correct? By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So we actually in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me reviewing the data.
It sounds like you're trying to justify.
Oh, I'm not trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct? Or
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faraday, but no, best practice would be to Faraday. I 100% agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report
Sure.
show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yeah.
There is activity on
Absolutely.
this phone.
Absolutely. The
Which
phone-
shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box, and that failure is not best practice.
Correct. It is not in accordance
Thank
with the
you.
best practices. I agree. I would have Faradayed it.
Thank you. So,
If I,
that's
presuming all
okay.
things.
I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
Piggybacking on your comment, Ian, the brilliance of Bob Alessi in terms of his cross-examination of Dr. Wolf, it was one of the most unorthodox starts to a cross-examination that you will see, but it was ingenious and it was done for a reason. It was very clear that their Dr. Wolf was a brilliant man, a very experienced witness and very confident, and he was going to be a big challenge to cross-examine. But if you'll remember, Bob started his cross-examination by introducing himself, saying it's a pleasure to meet you, and tell me about your normal day. And Dr. Wolf was an experienced witness, and he was happy to talk about what he does during the day, including, getting up early and making his wife coffee. And these seem to be the softball questions. And, Bob extended that day into a week, I think. And it was only at that point that having completely set him up, invited him for dinner and put the plate in front of him, that Dr. Wolf realized the food was actually poison. Because that's when Bob struck, if you recall, and said, geez, you know, that your day is fascinating and you're doing important work, but I didn't hear anything about forensic pathology, which is the topic that he was called on to testify to, you know? And I think at that point, Dr. Wolf realized he had been had, and he got a little angry on the stand and said, well, you could have just asked me if I'm a forensic pathologist. I'm not. But you know, in facing such, he was probably the most difficult witness or the most formidable witness for us to cross-examine in the whole trial.
Morning, Doctor. I don't think we've had the pleasure of meeting. Welcome.
Thank you.
Sir, can you just describe, you started to do it a little bit on direct, a typical day for you?
I wake up at 4:15 in the morning. I go to my center. I set up patients with frames for their either radiosurgical procedures or stereotactic craniotomies. I go home. I make cappuccino for my wife at 6 o'clock in the morning. And then I get back to work at 6:30 and move on. I have patients that I'm operating on, and I have patients that I'm seeing through the day.
What type of patients and what type of work? Just in a typical day. What are you doing? What type of patients and what do you do?
It varies. I mean, I see patients with brain tumors. I see patients with hydrocephalus, which is water in their brain. I see pediatric brain tumors. I see subacute and chronic subdural hematomas, post-traumatic. I see patients with strokes that are being misdiagnosed. I see patients with cancer, metastatic disease. I used to see patients with cervical problems. I stopped doing that 2 years ago. I don't know what else you want me to tell you.
No, that's great. And is that typical day, typical of the type of days you've had for the past month, past few years? Is it generally, without specifics, is it generally?
Correct.
So, none of your typical days, none of the past typical months have involved forensic pathology, have they? You haven't acted as a forensic pathologist in...
I am, if you could have asked that question very straightforward. I am not a forensic pathologist. I'm a brain surgeon.
Right. And you don't perform autopsies, correct, sir? You're a brain surgeon.
Correct. In other words, I see more brains than the forensic pathologist.
Right. And is it correct to say that the brains that you see are of living people?
Correct.
Okay.
With Dr. Welcher, when he was, you know, and his only could do his Dr. Welcher voice was like, what's possible? Well, it's possible that Lexus could have gone in reverse and jettisoned into the universe. And I said, did you just say that it's possible? And he said, well, yeah, I'm an engineer. Anything's possible. And then when I said to him, I said, you know, and it was just a reaction. I said, okay, let's get back to reality.
You don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not possible.
So your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space?
Yeah, highly, highly unlikely. But
Right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. And civil ethics mandate that one is truthful about their professional credentials, correct?
Correct.
And a fundamental credential is what type of college degree you hold, correct?
Correct.
People rely on those credentials, and the credentials are the foundation of your expert opinions and analyses, correct?
They can be, yes.
They can be, and they often are, correct?
Yes, they can be depending on context.
But more often than not, they're important.
Yes, again, depending on context.
So Your Honor, he puts his opinion in quotes, which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that one, he's qualified, and two, that his methodology is reliable, but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. All of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it, because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. Penetrometer resistance and shear strength of...
Why don't you put those in writing? Was that just a Google search? I saw that you had it on your...
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all.
No.
Happy to provide it, Your Honor. And do you recall what your testimony was with regard to alcohol consumption and small ulcers in the stomach potentially associated with alcohol consumption?
Alcohol consumption, I don't recall my exact words at grand jury, but alcohol consumption can lead to gastric ulcers.
And alcohol consumption can lead to gastric ulcers, and what medications can treat gastric ulcers?
Well, they don't treat them, they prevent them, but that would be a proton pump inhibitor such as omeprazole.
Right. So, isn't it correct, therefore, that the ulcers that are observed in the stomach of Mr. O'Keefe that we talked about, the gastric mucosa, could have come from ulceration due to alcohol consumption?
It's possible.
As opposed to hypothermia, correct?
Correct.
At the grand jury, did you testify as follows? If the injuries had been sustained in a different environment, where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. You recall that?
Yes.
You provided the Commonwealth, the defense, and the court with your CV in this case, correct?
Correct.
Mr. Burgess, you have in front of you your CV that we just spoke about, and I'd ask you please to draw your attention to the education section where underneath in red it says BGS, and then, do I read it correctly? It says Bachelor of General Science in Mathematics and Business Administration, University of Alabama - Birmingham, Alabama - currently pursuing. Did I read that correctly?
You did read that correctly.
Thank you, sir. The entire proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render, and his methodology not only is not reliable, but it's not even documented. They said his master's thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do? I went and read both of his theses. What I found is particularly probative of the issues I just raised. So I looked at his and read I read 179 pages of his 2016 Master of Science thesis that they cited. In it, he talks about, on page 46, defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate in his thesis that he confirms Dr. Russell's methodology. What he doesn't do in his thesis is even mention his own methodology that he used here. In 179 pages, there is not one reference to the methodology he used in his report. In conclusion, where is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home because it's not generally accepted. So he is not qualified under Dalbert Lanigan, and his methodology is an orphan. And for those reasons, not only can he not testify with regard to whether the cause is a sharp object, but he has not, the Commonwealth hasn't even begun to meet its burden that his methodology is reliable for all the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance, and Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case. You state that you placed the iPhone inside a freezer, correct?
Correct.
In digital forensics, you work with law enforcement often, correct?
Correct.
And you work in law enforcement in investigating cases, do you not?
Yes.
And so oftentimes, the law enforcement is using your digital forensics information to help them solve cases, correct?
Correct.
You didn't suggest to anybody on law enforcement that they might want to take a look at this temperature information to assist in determining where this phone could have been by the temperature? You never raised that with them?
I did not.
And do you know whether any law enforcement person was aware that you had done all this temperature analysis?
It was in my report.
So you create a report as part of this case, and you deem the temperature important enough to do 2 test scenarios, important enough to put it in a slide presentation to this jury. Yet there's no discussion of that between you and any member of law enforcement as to what it means?
The details were provided in my report, and there was discussions, but it never came up as to say what was the temperature in Canton that night.
Oh, so there were discussions.
Not with law enforcement.
Oh, who were
As
the
part of my preparations for trial.
Oh, tell me about who you discussed this temperature information with.
It was with Hank.
You're hesitating, and I can't hear you. Who did you discuss
with
it
Hank?
with? Excuse me?
With Mr. Brennan.
Attorney Brennan?
Yes.
You discussed temperature with Prosecutor Brennan?
It was in my report.
It was in your report, but you said you discussed. Which is it?
It's in my report, and the discussion was that it is in my report. I'm not in a position to suggest that investigations take place and change based on my report findings.
Oh, sir, I'm not suggesting what you just stated. I'm just trying to get information about, you mentioned the verb discussed. Didn't you, in your
Yes, I
answer
did.
moments ago?
Yes.
Isn't discussed a verbal thing? It's not a written thing?
It was discussed in preparation for trial, yes.
Oh, so there was a discussion, a verbal discussion with Attorney Brennan about temperature in your preparation for trial.
Yes.
Was there any interest at all as to what this could actually mean for the potential location of Mr. O'Keefe's phone on these very important time periods in January 29th that might assist to determine at various times whether Mr. O'Keefe is in a covered building based upon the temperature rather than outside in a nor'easter on January 29th?
I'm sorry, what was the question there?
Yeah, the question is, was there any discussion about the investigative value of what you had done in determining where that phone could have been on key time periods on the morning of January 29th?
That wasn't part of the discussion, no.
It wasn't part of the discussion. We went through, you may recall in my questioning, in your report, where you stated that it was possible that the phone could be inside the house of 34 Fairview based upon that big white circle. You testified that the low accuracy at certain points could be because of it entering a covered building, correct?
Correct.
And you do a temperature experiment to track the very accurate temperature change of an iPhone, and it doesn't match up the actual data with either of your test scenarios, and you don't raise that with anybody. Objection.
Sustained. You can ask it differently.
Did you ever put together in any kind of form your test scenario 1, your test scenario 2, and the actual temperature chart of the iPhone of Mr. O'Keefe?
So how do you mean put it together? As in compare the two?
Exactly. Compare the two and reach any conclusions about location, because you spent time, did you not, sir, a lot of time in your reports on location of the phone.
Yes.
But yet, with all that data, all that testing, all the experiments that you did, you didn't include in your slide presentation and you didn't include in your report what that could mean for the location of the phone, did you, sir?
I'm struggling to see the comparison there.
Let me see if I can ask it in a different
Please.
way. Nowhere in your slide presentation did you have any discussion yesterday about how your test scenario, did you bring up, by the way, in your slide presentation yesterday, your battery temperature at all? Your tests?
Not the tests, no.
Great. So you didn't even raise yesterday in your presentation about where the phone might be located. You didn't even raise the experiments that you did, correct?
Sustained as to the terminology. Ask it differently.
Did you yesterday, in your presentation to the jury, in any way, discuss your battery test scenario 1 and 2 in your March 2025 report?
I believe there was mention of testing, but not to the amount of detail to say what the testing was.
Right. So there was no detail given at all
No
about
detail.
it. You just mentioned that it occurred, but no detail in your discussion
Correct.
at all. And are you aware, with regard to the battery temperature, that battery temperature in investigations can be used to determine locations of phones at certain times? Are you aware of that?
No.
So you have never used battery temperature information in all your years in any way for any investigation of a case in determining location of a phone?
Again, I don't see how you can determine location of a device from a temperature reading, other than to say whether it was inside or outside.
So battery temperature and the chart that you gave that is up there, in your opinion, has no relevancy to the topic of where a phone might be to investigators in a case? Is that what you're saying?
Is that what you're saying, Mr. Whiffen?
I'm saying I can't take a temperature reading and make a determination about a GPS location based on the temperature reading.
That's not my question, though,
Okay.
sir, and I appreciate your answer, though. My question is, you work with law enforcement investigators regularly,
Yes.
correct? Isn't this information of potential relevance based upon your experience with investigations? Isn't this information at least potentially relevant in investigations?
I believe it could be. That's why I included it in my report.
Thank you. But you didn't include a discussion of it in your testimony yesterday, correct?
Correct.
Did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
Do you believe that the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
Not from falling backwards and hitting one's head, but that area at some point came in contact with the blunt object or surface.
Okay, if I could follow up on that, please. So, you agree that if a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
Correct.
All right. And if somebody falls backward and hits their head, they can't sustain, from that impact to the back of the head, a laceration to the nose, correct?
Correct.
Ms. Hartnett, on your direct examination, you stated that there were 2 stickers and that there were therefore glass associated with each sticker, correct?
Yes, that's correct.
So 2 stickers and glass associated with each sticker, correct?
Yes, correct.
In fact, there's only 1 sticker, and the second sticker is merely a reflection of the first sticker, and therefore you have doubled the stickers and you doubled the amount of glass on bumper. Can you see that? Can you determine that from the photo?
No, can I see the other photo, please?
Yes.
Okay.
So if we could, Your Honor, with your permission, go to Exhibit 133. You asked to see this one. Can you now make a determination, having seen both of them, whether there is in fact just 1 sticker and therefore 1 volume of glass associated with it?
No, I cannot. You're saying this is a reflection?
I can't testify,
Okay.
so I'm asking you.
With Your Honor's permission, if we could go back to the other picture,
Okay.
and you could zoom in. Do you see a reverse B in that picture?
I'm sorry, I didn't pick that.
I'm sorry, a reverse B as in Bob?
No, could you zoom in on each of the stickers for me, please?
We'll do whatever you would like to do to answer the question, so.
Sure. And then if I could just see the other sticker, please.
Absolutely.
Yes, I believe that is a reverse B, correct.
So therefore, can you now conclude, because of the reflection and because of the reverse B, that there is only, in actuality, and there was only in actuality, one sticker and one B, and therefore one volume of glass associated with this bumper?
I don't know specifically that it's a reflection. It's not unusual for me to use the same letter on a sticker if I'm going to collect the items of evidence together. So if I had written it, on top or on the bottom of the scale on one of them and on the top of the scale on the other one, that is a possibility. It's difficult for me to tell by this picture. What I can tell you is that all the items of glass or apparent glass that were present on the bumper were collected together. So I can't say specifically by looking at this photo whether I just label two separate areas to make the photo show the pieces better or if it is a reflection. I can't say.
So from what we just went through, we're not able to tell that that is a reflection and therefore a duplication. Is that correct?
I'm
Listening.
Do you have any doubt whether there is a reflection on the photo that is on the screen at this moment? Do you have any doubt?
Oh, I would say it could be a possibility, yes.
Right. So you have doubt. So you believe it's a possibility?
Yes, correct.
Is it more than a possibility?
Yes.
You would agree that it's important to have the accurate answer to that question, correct?
I think that, yes, obviously understanding and knowing exactly what I'm looking at is important, but it would not change what I would have collected and how I would have labeled it.
So, with regard to what others might do and conclude from that, it could be important to them, correct? In both of those CVs, you indicate that you have not yet earned a bachelor's degree.
That is correct.
And you certainly have not earned a Bachelor of Science degree in any educational field according to those two CVs, right?
Correct.
And in fact, as you sit here today, you do not possess any bachelor's degree.
Correct.
And the reason, as you state, is because that bachelor's degree is currently pending. That's the term you use.
So I use currently pursuing.
Currently pursuing, yes. So you have a public profile that's published on Aperture's website, correct?
Yes, I do.
And it's in the form of a biography page?
Yes, I believe so.
And that biography page has your education listed?
Very possible, yes.
Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is obligated to pay at least $325,000 And is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates. You said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work, about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign a contract. I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact between the Lexus, the back of the Lexus, and
Correct.
the Cherokee, correct?
Right, but I don't know where that is on the road.
Yeah. You don't know that. I want to go through the information that you don't know.
Okay, doke.
So you don't have that. You don't have the point of impact. You don't have where in the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
Right, and you don't have that information.
I don't have where it started.
Secondly, what Mr. Green pointed out on the issue of was this search deleted, there were 4,056 searches on the phone of Miss McCabe. 4,056. There was one deletion out of 4,056, and guess which one it was? House long to die in the cold. There are no odds that that can happen randomly, that one search out of 4,056 is deleted. So what does Mr. Green say? He says that strongly suggests one of two things. Either there was user interaction deletion, or there was post-imaging manipulation of the data. He doesn't accuse individuals. He says user interaction or post-imaging. That is the job of a digital forensic person, to point that out and say that raises concern. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point that out. Another key thing he points out is an anomaly. The Commonwealth said there was a tab number for Hockomock Sports, in that they said it was the same tab number for how long to search or how long to die in the cold. But Mr. Green points out that's incorrect. They had two different tab numbers. So that theory of the prosecution can't be right. So Mr. Green wasn't hurling accusations. He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Let's go back to the 22740 timestamp and the question of whether that timestamp is associated with a Google search, house long to die in the cold. You understand there is a dispute as to whether that search was performed at 2:27:40 a.m., as the timestamp states, or whether that was performed later in the morning, say around 6:23 a.m., correct?
Correct.
You understand there's a dispute.
Yes.
And do you understand that the defense asserts that that timestamp means what it says? The Google search occurred at 2:27:40 a.m. Thank you.
Do you understand that?
I do.
I didn't hear your answer, sir.
I understand.
You understand that?
Yes.
So there are various data forensic tools, are there not, to evaluate what is called an artifact, this timestamp, correct?
Correct.
And those data forensic tools include Celebrite tools, your company's tools.
Yes.
And some of those Celebrite tools are called Physical Analyzer.
Correct.
And then you have another tool, I believe, called Insights.
Insights is a suite that includes Physical Analyzer. Okay. But yes.
So it's Insights is a
It's
suite.
essentially the same tool.
Essentially the same tool. So this Insight, well, essentially, but they're two different tools, correct?
They're two different versions of the same tool.
Thank you. Two different versions of the same tool.
Yes.
But there are other tools from other companies, are there not, sir?
There are.
And a competitor of Celebrite that can be used to analyze that 2:27:40 a.m. timestamp and to potentially resolve that dispute of whether the Google search "How long to die in the cold" occurred at 2:27:40 a.m. or later at 6:23 or so a.m. There's other companies and tools that can be used for that, correct?
Correct.
And isn't one of the companies that can be used a competitor of Celebrite called Magnet Forensics?
Correct.
And they have a tool called Axiom, A-X-I-O-M, that evaluates questions such as this, correct?
They do.
And is Magnet Forensics a reputable company?
They are.
Am I correct that yesterday you essentially said that as of today, no Celebrite tool, no Insight suite such as Physical Analyzer, today shows that 2:27:40 a.m. timestamp?
Correct. If you use any version from the last approximately year, that timestamp won't show up.
It won't show up as you sit here today.
Correct.
But that's not always been the case
Correct.
with regard to Celebrite forensic tools, correct?
Correct.
As a matter of fact, in the first proceeding in this case, in June of 2024, when you testified under oath, the situation with the forensic tools was Celebrite Forensics Insights did not show the 2:27:40 a.m. timestamp. What? Another version of Physical Analyzer did show it, correct?
Correct.
In that second program, that second tool, Physical Analyzer, not only showed it at 2:27:40 a.m., but it showed it as a deleted state, correct?
It's a deleted record, yes.
A deleted record.
Yes.
Did you mention that yesterday in your direct testimony?
I don't believe so.
You don't believe so?
No, we changed it since then.
Exactly, you changed it since then.
Yes.
Your company removed it
Yes.
after the first trial.
Before the first trial.
Well, you removed it from one tool before the first trial, but you didn't remove it from the other Physical Analyzer program, did you?
Up until the following version was released.
No, I'm talking about the time of trial when you were testifying.
I appreciate that. There's some complexities with how we released the software, which resulted in one being released several weeks later and one being released several weeks earlier.
At the time of trial,
Yes.
last year in June, when you were testifying under oath, one of the Celebrite tools showed the timestamp of 2:27:40 a.m., correct?
Correct.
But that timestamp doesn't exist anymore. It doesn't exist today, does it?
Correct.
Celebrate removed it.
Yes.
So with regard to the first proceeding, there was one Celebrite forensic tool that still showed the 2:27:40 a.m. timestamp,
Correct.
and it was shown in a deleted state.
The record was deleted, yes.
The record was deleted. And then after that, Celebrite outright removed the timestamp from, so none of its programs had it. Correct?
Again, if I could explain a little bit about how it works.
No, I'm sorry.
Okay.
If you could just respond to my question. Is that correct?
The timestamp's been removed, yes.
However, the competitor of Celebrite that we just talked about, Magnet Forensics Axiom,
Yes.
that program at the first proceeding showed the 2:27:40 a.m. timestamp, correct?
Correct.
And as a matter of fact, as you sit here today, the Magnet Forensics program, Axiom, still shows the 2:27:04 a.m. timestamp, correct?
As far as I know, yes.
And Magnet Forensics Axiom is a reputable company, correct?
Correct.
Celebrite removed that 2:27:40 a.m. timestamp, which is in a deleted state, in response to issues raised in the first proceeding, correct?
It was changed because of the research that I did, and that was verified by the forensic research group.
But the issue arose because of what had come up in the first proceeding, correct?
In the first investigation prior to the proceeding, yes.
In the first investigation in this case, correct?
Yes.
So Celebrite, after the first proceeding, after the investigation, just outright went and removed the timestamp.
It's not unusual to change the
I
code.
didn't ask if it, I just asked whether
Yep,
they
we removed it.
But Magnet Forensic Axiom still shows that 2:27:40 a.m. timestamp, right?
Again, they refer to it differently, which is why they can
But they
do that.
still show it.
They do still show it.
In that 2:27:40 a.m. timestamp, the dispute is whether it's associated with the search, House Long to Die in the Cold, correct?
Correct.
Let us now go to the timestamp of 2:27:40. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going to
was
test.
more than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. So it reads, in the instance of the Google search, House Long to Die in Cold, that was recovered from the write-ahead log associated with the X-Browser State DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
Fair. Yes.
So you use the words that Google search, House Long to Die in Cold, was associated with the timestamp of
2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. It starts with, there were 2 searches of interest that took place on the iOS device, and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's. Yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her
Absolutely,
device, right?
yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase identified to me as Jennifer McCabe's.
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
And do you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I've been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
You, on page 5, in the sentence underneath the block paragraph, state, in the instance of the Google search, house long to die in cold that was recovered from the write-ahead log associated with.
That's correct.
The X browser stage with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead. Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27:40 is unknown. Sorry.
So you use the word unknown, your word in your report.
Yes.
Okay, and then if you go down to line 22, you testified in that proceeding. So it's important to use multiple tools so you can see the results from different different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did, that's correct.
And then going up to page 114, line 5.
Slow down a little bit, Mr. Alessi.
I will, Your Honor, thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. XQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term house long to die in cold, and I'm going to skip over, in addition to my own previous report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's
That's a fair statement. That's a fair statement. Let me rephrase it this
Thank you.
way. You're welcome. In this report, you speak about Celebrate release reports, correct?
Are you referring to the Celebrate release notes
The
that come out?
release notes at the bottom,
Perfect.
right? You referred
Yeah.
to that?
That's correct.
And that release note states that Celebrate has removed the timestamp value from records, and I'm assuming that's a reference to Celebrate's.
Celebrate no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure. I'm there.
And I'm going to go down, all the way down to the conclusion. In that report, is there reference to any company other than Celebrate in this entire report?
In this report, no.
Okay, thank you. Now let's go to your prior testimony in the first proceeding, where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now, however, isn't it correct that in your report of December 2024, you had an issue with the hash value from the data from that phone?
I didn't have an issue with the hash value at all, no.
So you didn't note that it was not possible with the gray key extraction, as the PDF containing the extraction hash value, that it was unsigned? That was not an issue in your report?
The hash value matches, but because I didn't do the extraction, I'm unable to actually validate that was an original hash and hadn't been modified.
Exactly. So you didn't do the extraction, but you couldn't validate the hash value, could you?
No.
So you couldn't determine whether or not any of the data on that cell phone of Jen McCabe had been tampered with, correct?
I take a holistic view of the data and try to find anomalies and didn't see any that raised any flags.
That wasn't my question, sir.
Okay.
I'll try it a different way. You concluded that the hash value was unsigned, correct?
Correct. They were always unsigned. Okay, apologies.
You concluded that the hash value was unsigned, correct?
Correct.
Thank you. And you went on, did you not, in your report, to say that this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%, correct?
Correct.
Did you discuss any of that doubt, that suggestion of authentication but can't be guaranteed 100% at all in your direct testimony yesterday?
I didn't know.
And again, hash values are very important concepts for data forensic examiners, correct?
For integrity, yes.
Do you know the chain of custody of Jen McCabe's iPhone?
I don't, no.
So you don't know the chain of custody of her iPhone. You have an unsigned hash value, and you can't guarantee the hash value authentication, correct?
No.
The objection's overruled.
Not from the hash value, no.
And indeed, that is the bio page that's published on Aperture's website, correct?
That is what it appears to be, yes.
Now, I would like you, sir, to turn to page 2 of that document.
Okay.
And I'd like to turn your focus to the bottom of education heading.
It states, am I correct, sir, BS, Mathematics, and Business Administration. Is that correct?
It does state that, yes.
And there is no qualification if it's currently pending. It states BS in Mathematics and Business Administration, correct?
That's what it states there, yes.
And you do not have a Bachelor of Science in Mathematics and Business Administration, do you?
No, I do not.
And if you click on the hyperlink for your CV on that same website, do you know where that hyperlink takes you?
No, I do not.
To any member of the public reading this, including prosecutor, a defense attorney, a judge, or a jury, that represents that you received your Bachelor of Science in Mathematics and Business Administration, does it not? Objection.
That's sustained.
Now, if you continue on to your photograph, are you familiar with Aperture's website that speaks about you and presents you generally?
Vaguely, yes.
Are you aware that Aperture has two hyperlinks, one that says CV and one says LinkedIn? Are you aware of that?
Yes, I am now.
And LinkedIn is a professional networking platform designed for career and business professionals to connect, share content, find jobs, etc. Is that a fair description of LinkedIn?
Yes, it is.
And could we also conclude that it's a professional networking platform, especially for private sector firms like Aperture, that's used to attract clients or potential clients?
Yes, correct.
And potential clients include, for example, the Commonwealth of the state of Massachusetts, correct?
Correct.
And indeed, the Commonwealth is no longer, if you will, an attracted client, but it's an actual client of Aperture and you, correct?
Correct.
And that's the status of the relationship here. Aperture is a client of the Commonwealth of Massachusetts in this case, right?
Correct.
So is it fair to say that your CV, especially when it's published on a LinkedIn or published on a website, is something that is published to intend to have, especially if you're in the private sector, have clients view and retain your services? That's a hope and an expectation, correct?
Yes, that is part of it.
And so I saw what Welcher was doing. I put my crumbs in on my physics with force equals mass times acceleration. The fact he did it with the head but not the arm, which is a cardinal sin for a biomechanist if you're not going to use Newton's second law and you're going to try to do a kindergarten paint experiment. On
direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now, given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. You didn't present a force calculation in your materials, as you've stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand, okay? So that's my definition of a right arm.
You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm, from the shoulder down to the tip of the fingers, is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get you what you have depicted in your diagram of how to pull the arm out. And that's not a glancing impact. Is that sort of with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. So let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Okay,
Tell me when you're ready.
go ahead.
So let's take a scenario where it's a center of impact.
Center of mass.
Center of mass impact, right?
Okay.
Impact to the right arm.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for the impact window.
Okay. Question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical, semi-algebraic application of the numbers, correct? You divide.
Correct. We're doing a little simplification in terms of the crash pulse shape, but generally, yes.
Right. So, but let's take the conservative number, the lower number, 2188, that you came up with. Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force, if you would get to have to cause a break at the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to do your calculation? I'm asking about a center of mass impact.
How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, you know what I'm referring to, the phalangeals,
Yes.
the metacarpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand, but I'm asking, do you know from the literature, not a calculation, doesn't the literature tell you, can't you go to the literature like you did with the head, and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're going to need higher.
How about another part of the back of the vehicle?
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of.
The
contact
Lexus
area.
SUV. Let's assume, I'm sorry.
Can you repeat the question, please?
Absolutely. Thank you. Let's assume we're talking about this Lexus SUV. Right? But let me back up. You don't know where exactly, under your theory, that there was a contact. You don't know, if you testified to on direct. You don't know exactly where that point of contact is.
Correct.
You don't know.
Except it's on the taillight.
Well, you're saying it's on the taillight, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see any impact, right?
That is correct.
So, and there is no first-hand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, right?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities, I deal in probabilities. It's not probable.
But you don't know exactly where the point of impact was.
So within the range of the light and the exact angle of the hand, no, I don't.
So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading, you will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight of Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers, okay? You said 300 and 750. Did I hear it correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So if you're above 350,
300.
above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,412 pounds above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't. What was the? You said
2,180.
You said dyslexic. Or did you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay?
I didn't hear it.
You came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay, so let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight to Mr. O'Keefe showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed, but what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I've distributed it over a larger area, so for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not your bed, but for a Lexus SUV of 6,000 pounds, is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay, so probably, your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper? Potentially, yeah. But from a taillight or a broad flat surface? No.
I'm not asking about a taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force.
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger, so your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient, sorry. Mr. Wolf, can you pull up a slide from Mr. Wolf's or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that? Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there any part, for example, the edge of the license plates, above the license plate, the L symbol that sticks out that would be concentrated? Anything you see there could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand.
So, I don't know how to show this because in the middle photograph, right where that 2 is on the license plate,
yes,
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right, so now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is the number I calculated for you. It's not, quote, my number.
I understand, but we did. I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that?
I'm sorry, what, to the hand? Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, I don't know if you can see the little dot. I'm talking about this area.
Yes.
Right here.
Yep.
So that transition between the two body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well. It's a much more narrow loading condition.
How about the corner of the tail lamp?
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
But you didn't do any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct.
Some of these location records are shown in the map below in white. So let's go down and look at what you had in your report for the area in white. In the area in white that you're referring to, there are 2 white circles, the largest one there. This, in fact, was a depiction that you included in your report on page 29, correct?
Correct.
Interesting and notable, you did not include that depiction in your timeline that you discussed with the jury yesterday, did you?
I did not know.
But it was important enough for you to put that depiction in your report, correct?
Correct.
And notably, the larger white circle covers a substantial amount of the house at 34 Fairview, correct?
Correct.
So, given your testimony on direct yesterday with Attorney Brennan, the phone of John O'Keefe, according to this depiction, could be anywhere within the largest white circle, correct?
Correct.
And this depiction was not offered by you or the Commonwealth in your presentation to the jury yesterday, correct?
Correct. Not in the PowerPoint.
Now, if we could go back, Mr. Wolk, to page 29 of your report, into the text, and if we can enlarge the text just a little bit, please, for the jury, Mr. Wolk. So, the paragraph that begins with at 12:38:13, when the device begins recording higher accuracy information. Again, the data centers on a location slightly closer to the house than the roadside, although several records show the same center coordinate with differing accuracy radii. Some of these location records are shown on the map in white below. And I repeated that just to to connect this part of the text to that diagram with the big white circle. Have I done that correctly?
Yes, correct.
Thank you, sir. The next paragraph. Over the next few hours, the GPS coordinate and the associated accuracy radius jumps around numerous times between the house and the road. Did I read that correctly?
Correct.
And therefore, over the next few hours, according to your report, the phone of John O'Keefe could be in the house, correct?
Based on the low accuracy information, yes.
The answer is yes.
Yes.
Do you recognize that document, sir?
Yes, it appears to be a screenshot of my LinkedIn account.
I would like to turn your attention to your the printout of your personal LinkedIn page and go right to the second page, bottom. And under education, it says University of Alabama at Birmingham. It's got a little UAB acronym there. And it says Bachelor of Science, paren, B period, S period, comma, Applied Mathematics and Scientific Computation, 2016-2018. Do you see that, sir?
Yes, I do.
That's not correct, is it?
No, it's not correct.
And you do not hold a BS in a Bachelor of Science in Applied Mathematics and Scientific Computation from the University of Alabama at Birmingham, do you?
I do not. And that would have been, at that time, an expected graduation date?
So it would be expected, you state.
Correct.
It would be another word currently pursuing? Is that similar to expecting?
Sure, that could be similar.
But you know how to put currently pursuing down, don't you, sir? Because you did it on the first few CVs, but you don't have it on your LinkedIn page. Am I correct?
Correct. That's probably because obviously that has not been updated in quite some time.
And
You said you get notifications when people access your LinkedIn page, correct?
I get selective notifications when people view my LinkedIn page.
So you know people are looking at your LinkedIn page, you know people are looking at your education, and you have down here 2016 to 2018. So that time period is 7 years old from 2018, yet you use the 2016 to 2018 on your LinkedIn page, correct?
Correct. With the caveat that my understanding is people look at your post, not specifically the profile information.
Oh, so you believe you know apparently when people are looking at it and what they look at?
No, that's not what I'm saying. I'm saying generally.
So a key aspect of your credentials, whether or not you have obtained a Bachelor of Science, is incorrect in more than one document that I've presented here today, correct?
No, I would not agree with that.
Well, it's incorrect in this one, correct?
Correct.
Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So, based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time.
I will tell you that anytime you saw me in court, there was zero theatrics. It was all natural. It was just what came from me at the moment. And you astutely point out that one is one of the apexes of that. I call it the ARCA hoax. It was a hoax from the beginning that there were things that we were doing wrong, that AJ was doing wrong, any other member of the defense was doing wrong. It was a hoax. It was Brennan's stunt because he knew how devastating ARCA was to try to get them not to be able to testify. And it was from he got on the case right up into the bitter end, and he would gaslight and keep saying, I don't, I'm happy for them to, I just want discovery. I just want that. Oh, they can tell, and it was not what he was saying it was. And then, it was him provoking the judge. I'll never forget it. It was February 11th, and then we had to come back February 18th. But it was all a hoax. It was a hoax, but it was serious because the judge was on the precipice 3 times to pulling the pro hoc vice. And I fought it with everything I had. David knows that I spent, and this wasn't what I signed up for. I had a full practice. This was pre-trial. I spent 8 full days preparing for that in every angle because, you get your pro hoc pulled in one jurisdiction, you're in jeopardy in every other jurisdiction you want to practice in. So when I was asked to defend that situation, I took it very seriously, but for the grace of God, that can happen to any of us. And I knew how serious it was and the seriousness of the consequences, but I was outraged. I was outraged as to not only the hoax, but the degree of play it was getting, right? And the
grave concerns. The grave concerns.
Yeah.
So now my next question is regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time?
Same time as what, Your Honor?
As the invoice.
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. This was filed, I believe, on the weekend, February 16th. In the Commonwealth's opposition, defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your
Go
question.
ahead.
I learned that that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned...
You don't have to
I'm sorry.
repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. And I want to... So I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through, and when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, is signed by you.
Your Honor, it is signed by me, but if I could with regard to 3.3A1. 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1, the attorney in question has to know with regard to the fact in issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But, Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis in construction, Your Honor, would render mere surplusage and read out the mens rea of knowing.
in something that critical of candor to the court. That's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3a from everything else in the world, which I agree completely with Your Honor.
All right. I'm not going to ask other counsel.
There are no text messages in 2024, and there's no order that required those to be preserved, and there is no discovery violation because we can't be in violation of not turning over something that doesn't exist.
All right, go to the second.
Thank you, Your Honor.
Motion.
The second part of the motion, Your Honor, is the most maddening for the defense. And this is the timeline that I can go through very, very quickly. And essentially, what the Commonwealth just argued is we will be so prejudiced that if we get the work that ARCA is underway, working on, that we will be prejudiced because we won't have enough time to address it. Your Honor, the facts show that the timeline for this has been caused by the Commonwealth, not the defense. And I can do it quickly. July 2024, the first trial concludes. November 2024, 4 months later, the Commonwealth decides to retain Aperture. Their decision to wait 4 months to retain an expert, we're the defense. We defend what the Commonwealth alleges. January 30th, 2025. 2 months after that, and 6 months after the first trial, we get an Aperture letter report that's barely discernible about what they've done. It's a 1 page and 1/4 of conclusions and opinions in outline form. Next, January 31, 2025, we get the initial Aperture 140 slide presentation. January 31st, February 5th, we get the case file. In February 19th, we finally get the raw images from Aperture in the scans. That's the first time we get raw images and scans. You can't have an expert work on anything until you even get those raw images in scans. We move, and we have a hearing on March 20, 2025 to preclude Dr. Welcher because the slides are so incoherent and the report is so insubstantial. We can't tell what it is their theory is. So then on March 24th, and at that hearing, the Commonwealth agrees to redact and revise that. So we're already into March 20th. The Commonwealth agrees to redact and revise. Your Honor put the defense on a short leash. We accepted it, and by March 24, we receive the PowerPoint that was of the Aperture that was supposed to have two things happen. It was supposed to be redacted, and there were certain things that were supposed to be changed. What did we get on March 24th? It wasn't redacted, and there were 3 substantive changes to it. The Commonwealth has said twice, including today, there were no substantive changes. There's 3 of them, and to the extent Your Honor wants to hear, I can detail exactly what those changes were.
So why don't you highlight them very quickly, because I
will, Your Honor. Something. I can do it quickly. Thank you for the opportunity. First one, slide 36, they changed the image of 34 Fairview. No small change. 102, they changed the conclusion regarding the time that the tail light was broken. No small change. 123, they changed the image of 34 Fairview. No small change. So we ended up getting those changes, and I want to be clear on the date. That's March 24th. We have a hearing on March 25th. We agreed to provide our response to these revised Aperture documents. Here is the key data point. On March 26th, the defense engages ARCA. Just 2 days after we get the revised PowerPoint with 3 substantive changes. And then we started to respond and provide more information. On March 27th, we responded to the Commonwealth's revised PowerPoint and the Welch report, and then the last 2 items, we renewed our request to preclude Dr. Welcher on Dalbert Lanigan grounds. April 1st, and this is another key date, the court decision allowed Dr. Welcher to testify, but also allowed the defense to re-raise objections at trial when Dr. Welcher testified. What does that timeline show? That timeline shows that the Commonwealth took 6 months from the last trial. 6 months. And the defense took merely 2 days after they got the final report of Aperture to retain ARCA. Last point I want to make, Your Honor, is the argument of the Commonwealth that we strategically waited to retain ARCA. Nothing could be further from the truth. As the court knows, and has been the case with this unorthodox situation, ARCA was retained by the U.S. government. They worked pursuant to the U.S. government, and we had to get the permission of the U.S. government to retain ARCA. We moved expeditiously to do that. We got the permission from the government, and as soon as we got the permission from the government, and as soon as we got the final version of Aperture documents, including scans, we put ARCA on it. It has only been since March 24th, not even a month, have we had finally the information from Aperture, which is still inadequate. Our experts still say, with regard to what Aperture did, in some instances, they can't even figure it out because the information is so inadequate. Nonetheless, because of all the considerations we're aware of, we had ARCA proceed forthwith with post-haste. And they are working post-haste, but, Your Honor, we are the defense. That's where I started. We had to understand as best we could what Aperture did. In conclusion, 2 points. No violation whatsoever on text messages, emails, court orders. All complete, robust compliance. And with regard to the allegation that there was something said, that there's some surprise that there were so many text messages, on June 10th, 2024, and I've got the transcript albeit on an electronic device, right in front of me, I just got to get the passcode. Mr. Jackson read a text message right live that he had with Uncle. He read it, and here's what it said. The court, okay. Mr. Lally, so her issue is that she is available this week, but not next week, so I really need to get her in on Friday. Mr. Jackson.
Hold on. The court reporter can't hear you. She asked you to stop.
Oh, I'm sorry. My apologies. Am I going too fast? Yes. Thank you. All righty. Go ahead. Thank you. My apologies. So, Mr. Lally, so her issue is that she is available this week, but not next week, so I really need to get her in on Friday. Mr. Jackson. Dr. Wolf just texted me and said, I presumed you were in court. Give me a call when you're available. The court reporter, I'm getting an interference. Mr. Jackson, I'm so sorry. The court reporter, that's okay. We have been completely transparent that there were text messages, as opposed to emails, text messages about scheduling, about other administrative matters. Mr. Brennan is completely free on cross-examination of ARCA to address every one of his speculations every one of his suspicions, every one of the ghosts that have been created on this topic. He can address them. If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to ARCA and ask those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense from putting in a defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right.
So I need you to wrap it up because there's something I want to say.
Certainly, Your Honor. I'm going to wrap it up in 10 seconds. There are no violations of any discovery order, no violations of this court's order. And with regard to the retaining of ARCA, because we're the defense, we acted expeditiously in response to the information we're getting. And this can be tested with ARCA, this statement I'm going to make. To this date, ARCA still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Dalbert Lanigan motion, but we proceeded nonetheless. Happy to entertain responses to any questions.
All right. No, thank you. All right. So as you all know, I previously wanted you to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having the view. I need the ARCA witnesses here Friday morning.
What I'd like to do is to go back in time with regard to your interactions with the United States Department of Justice in February of 2024. Was ARCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCA for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in ARCA?
Let me just clarify something real quick. So the original case, when it came in from the Department of Justice, was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No.
To your knowledge, when you were entering time under that contract number for your work, did you understand that that time was going to be billed to that contract number with the U.S. government?
That was my assumption, yes.
Did you have, from any time in 2024, any understanding that any of your time that you were entering was to be billed to the defense team in this case?
No, sir.
Mr. Alessi, I only have one question for you. So would you stand, please? You're arguing this, right? This was your motion. So my question is, how do I reconcile the fact that 100 text messages were deleted by counsel? And we heard yesterday counsel's preferred method of dealing with Dr. Wolf was via Signal. How do we reconcile that with the Massachusetts Rules of Professional Conduct 1.15. I don't see how you reconcile that, where all correspondence related to the matter, whether in physical or electronic form, must be saved for 10 years minimum. How do you reconcile that? How do I reconcile that?
Should I go to the podium?
Right there, and I expect a short answer.
The short answer, Your Honor, is the rule that you're citing has absolutely no applicability to this proceeding for the, can I finish my answer, Your Honor?
Right ahead.
Has no applicability. That rule is intended to be between an attorney and the client. The court has no jurisdiction to enforce that rule.
I agree. I agree. That's a different body, but I'm asking you how I reconcile that when I'm trying to figure this out. Mr. Alessi, you know what? You're going to win this, so why don't you just let me make my ruling, okay? So I understand there have been repeated violations of the reciprocal discovery orders and my orders, repeated and deliberate. But, and Mr. Brennan, I understand completely the Commonwealth's argument, completely the ambush that has been set upon here. However, a defendant's right to a fair trial is paramount to everything. So I'm going to allow the ARCA witnesses to testify. I am going to allow what I expect to be a very robust cross-examination.
When you sat at the table and eat, did you just eat your ham sandwich, or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
Did you laugh a lot?
I assume if something funny was said, I probably laughed.
In the upper left-hand corner, there's a photograph.
Yes, there is.
Is that you, sir, in the photograph?
Yes, it is.
And in the spelling of your name, Shannon, that's with one N, correct?
Correct, yes.
And so that is not only you in the photograph, that's the spelling of your name with one N, correct?
Correct.
And that's the correct spelling of your first name with one N, correct?
Yes.
So that's definitely you represented in this document, correct?
Yes, that is correct.
Now let's look at the first line that relates to education. It states Bachelor's of General Science and Mathematics and Business Administration, correct?
That is what it states, yes.
And the date is 2022, correct?
Correct.
So this document represents that you received your Bachelor's of General Science and Mathematics and Business Administration in 2022, correct?
That is what it states, but there are a number of errors in that, yes.
Correct. So let's go on. So this is the third example, am I correct, sir? Well, let me, may I approach, Your Honor?
Yes.
Your Honor, at this time, I offer Exhibit XX into evidence.
No objection.
Okay.
Sir, is Exhibit 187 a CV that is linked directly from Aperture's website?
I do not know. I would have to look and check that.
So as you sit here today, you are not able to state whether that CV is linked directly from Aperture's website?
Correct.
So this is a third example of a document that incorrectly states that you have a Bachelor of Science when you do not possess that degree, correct?
It has errors or outdated information, correct?
Well, when you say outdated, how is it that you can call a date outdated next to something that you don't possess?
I don't understand your question.
Well, you just used the phrase either incorrect or outdated. I'm trying to understand your statement that it's outdated. Isn't it either you have a Bachelor of Science degree or you don't? Isn't it?
I have represented I do not have a bachelor's degree.
But in here, it's represented that you do, correct?
Yes, it is an error, yes.
So, let's look at what the name is that are on these documents. It says Bachelor of General Science in Mathematics and Business Administration. Do you see that, sir?
I do.
Are you aware that there's no degree at the University of Alabama, Birmingham, called a Bachelor of General Science in Mathematics and Business Administration?
Yes, I am, and that is one of the errors I identified.
So you would agree that there's not even a degree called Bachelor of General Science in Mathematics and Business Administration offered at the University of Alabama, correct?
Correct. That should be Bachelor of General Studies with minor in Mathematics and Business Administration.
And what you just articulated, you do not possess as you sit here today, correct?
That is correct.
What you possess is an associate's degree, correct?
Correct.
And when did you obtain that associate's degree?
So that would have been 2015.
Are you familiar with the term mendacity?
I am not.
Are you familiar with a CV of 2015?
No, I'm not.
Sir, do you recall when you started pursuing a Bachelor of Science degree of any kind?
Sure, I do, around 2008.
So you started pursuing a Bachelor of Science for the first time in 2008, correct?
Correct.
If I did the math correctly, sir, you've been pursuing a Bachelor of Science degree for 17 years, correct?
That is correct.
And you have not obtained it as you sit here today.
That is correct.
And yet there are the various documents that we've seen that state that you have obtained the Bachelor of Science, correct?
Again, with errors or misinterpretation. Yes.
Errors and misinterpretation that are you stating, but you would agree those errors or misinterpretation have been in existence for some time, correct?
Yes, I'm being made aware of them now, yes.
Yeah, and they haven't been corrected for some time, correct?
Correct.
Are you familiar with the phrase academic dishonesty?
Yes, I am.
We believe strongly, Your Honor, that at a minimum there needs to be a voir dire of Mr. Burgess. And we believe strongly there needs to be a voir dire because we have a serious concern that the sequestration order has been violated. He has changed a very key aspect of this matter after the testimony of Mr. Whiffen, after Mr. Whiffen presenting a timeline in his report, Mr. Burgess, his new purported report of May 8th. He references to align it with Mr. O'Keefe's cell phone. That is the essence of Mr. Whiffen's report. It is anchoring in his timeline. He did a whole timeline on Mr. O'Keefe's report. And conveniently, the proposed alteration by Mr. Burgess in his report of this clock drift now makes it very, very close to fitting within Mr. Whiffen's timeline and the theory of the prosecution. At a minimum, we need a voir dire to ask Mr. Burgess, why did he do what he did? Another reason for the voir dire. Mr. Brennan yesterday said, we were surprised to get the report. That further makes great concern as to why Mr. Burgess did what he did. I'm going to read the first line of your May 8th, 2025 report.
Okay.
Do you have it in front of you, sir?
I do, yes.
It starts, Dear Mr. Brennan. Do you see that?
Yes, I do.
Pursuant to your request. That's the request you're referring to of Mr. Brennan, correct?
Correct.
I have completed an additional analysis concerning the above referenced matter. To formulate opinions, the following additional items were reviewed. This wasn't done on your initiative. You put in writing you did it at the request of Mr. Brennan. Which is it?
So that was on my own initiative. This is a holdover, so a copy and paste from my original report.
You're explaining the May 8th report in your language pursuant to your request as a cut and paste from a previous report?
Yes, I am.
Do you cut and paste important information from one report to the other without checking it for accuracy?
I copy and paste certain portions.
Do you ever review what you cut and paste to see if it's accurate?
Yes.
You didn't review it this time, though, did you, sir?
No. I did not think it was significant.
Oh, you don't think it's significant, sir, that the matter is in the middle of a trial and there's a request for a new report after testimony has occurred in that trial, you don't think that's important?
Objection.
Sustained.
I did want to ask you about the hoodie moment, because that was a major moment in the trial. And for the people in the chat who don't know, Mr. Brennan presented a hoodie and suggested to the witness that the holes in the back of it could have been caused by road rash consistent with a collision. And that was not possible because the origin of the holes was known. It was known to be, from the crime lab. They cut those holes.
The defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie, and this regards questioning and representations in question by Mr. Brennan, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminal list, that those holes in the back were caused by their criminal list as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? And spoiler alert, there never was a collision. That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminal list as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice.
The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Ms. Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
I know of no better trial attorney in the country than Robert Alessi.
Good morning, Dr. Welter.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Alessi. Nice to meet you.
Nice to meet you.
Got so much knowledge, flow so unique, call it path harmonic. Don't get too close or this nerd will spray. I'm a walking, talking word of the day, hey. But be careful, I'm not all brains. Got a mean left hook that'll change your day. Don't even think about coming for David, or I'll put your blood in an affidavit. With my black gloves, I will legally scalp you. Got me looking like I'm about to tattoo you. In your theory, so many holes I poke. It's more bullshit than the ARCA hoax. Sorry, judge, but let me elucidate before you go and take our experts away. We want the jury to hear the truth, that John didn't have a bruise. It's what you do to me. Call me a lessonator, baby, I'm here for the kill. Talk nerdy to me, I'll be assiduous, baby, you know the drill. It's what you do to me. Call me a lessonator, baby, I'm here for the kill. I'll be assiduous, baby, you know. His cross exams are more like Hell's Kitchen. He'll beat your ass if he catch you bullshitting. Talk slick to Bob and you'll have your natty swinging. Circle round your house like my name Ian Whiffen. Mr. Burgess, you're faking degrees. Have you heard of the term mendacity? He knows now. How can a witness be talking so reckless and welch to outer space with the Lexus? Once I get going, it's real hard to stop. My rhymes are sharp and they're hard as a rock. Got the young Yeti and it's fully stocked. Give me the rock and I'll make the shot. Swish. How convenient that Google search is gone. But did you use Axiom? Probably not. Half man, half Vulcan, they calling me Spock. But let me assure you that it's just fine. Assiduous, baby, you know the drill. That's what you do to me. Call me a lessonator, baby, I'm here for the kill. Baby, I'll be assiduous, baby, you know the drill. Baby, I'll be assiduous, baby, you know the drill. Baby.